Hello and welcome. Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Bellomo, where we discuss all things estate planning and elder law, and well, hey, anything else we want to talk about. Now, on today's episode of the Red Wagon Estate Planning and Elder Law Show, I have a dear friend of mine and team member, Christine Oyler. Christine, how you doing?
I'm good. How are you?
Oh, I'm doing really well. I've been looking forward to this one for a while. Today is going to be all things elder law, all things Medicaid. So we have found over the last several years working together that there are some common things that come up that confuse people, but also maybe are not at all what people would expect. So we thought we would do a podcast related solely to Medicaid and also solely to things that are not as well known maybe, or something like that. So before we get into the content, I do want to remind people that you should not take anything that you hear from this show, or any other show for that matter, to constitute legal advice. If you are looking for legal advice, please contact an attorney licensed in the state that you reside in, who practices in the area that you are looking for advice in, and once they know the facts specific to your circumstance, they will be able to provide legal advice. This show, and any other show for that matter, should be for entertainment, educational, and informational purposes only. But today, we will certainly be talking about some common things as they relate to Medicaid, but the specific facts to your situation could certainly change the outcome or change the advice we would be giving. Today, we're here to have a little bit of fun, to talk about some things that a lot of people just don't know about. And as always, at Bellomo Associates, we educate, so what happened to my family doesn't happen to yours. We offer free educational workshops in the estate planning or pre-planning context, the Medicaid crisis planning context, whether it be in a nursing facility or in home care of the skilled nursing care variety. All the time, we are also offering life care planning, as well as special needs planning workshops and administration, whether somebody passes and they have a trust or whether they have a will with assets in their name alone. We offer free educational workshops in those areas. If you are looking for advice in those areas, please come to one of our educational workshops. You can learn about them at www.bellomoassociates.com. That is B as in boy, ELLOMO, associates spelled out with an S.com. Or give us a call, 717-845-5390, and the office will be able to give you all of the upcoming workshops for any of our educational workshops, which are all absolutely free. All right, wonderful. All right, so Christine, we're going to have a little bit of fun today, talking about some Medicaid topics. I thought the first one I wanted to bring up was 529 plans. And how, if somebody was to enter a nursing home, or if somebody was to be in their home looking to get skilled care in the home under the waiver program, and we were going to file a Medicaid application for that family, of course, we look back 5 years. Now, just as a reminder, the 5-year look back period is nothing more than, imagine putting a box on a table. And we're going to put in that box every statement of every account for the past 5 years. In that box, there would be a 529 account that would appear because it's an asset within the past 5 years that we have. And so now we're going to take a look at the 529 account. So, Christine, how would Medicaid look at a 529 account?
So 529 account would be a countable resource sitting there in that box, like you said, and so it would then affect their eligibility for Medicaid approval.
Okay, so give me an example. I have grandma. Grandma opens a 529 account for grandson, and it is in a 529 account for the grandson, but grandma created it, still in grandma's social security number. And it would be intended then for the grandson at the time that the grandson goes off to college or whatever educational opportunities grandson is looking for. Is that a fair statement?
Yep.
Okay.
Yeah, so it's going to be grandmom's asset at that point in time.
Yep, absolutely. And I know for some of you, you're going, wait a minute, hold on. I'm allowed to do this, of course. And as always at Bellomo Associates, we teach this concept called three lands, right? I always teach tax land, long-term care land, and estate planning land. So this is exactly the example that we're trying to highlight, which is from a tax perspective. There is no question that a lot of grandparents are gifting the annual exclusion gift of $18,000 a year. They're funding it into a 529 account. The last I did the research, you could even front load 5 years for the 529 accounts and put them all into 1 year. Sure, from a tax perspective, there is no question that it can be done. So please don't take anything I'm saying to say that you can't do that from a tax perspective. But what we're saying is when you're in long-term care land and we look back 5 years, that account is in the box of the 5 years of statements. What we're saying is it would be an available resource for grandma's Medicaid application. Anything else you want to add about that one?
Sure. Also about 529 plans, what happens then when they are actually the grandson pools money to pay for the college tuition? It's then now a gift if it's within the 5-year look-back period.
Okay, so it's an available resource, and then as the money is pulled out, it would be considered a gift. Okay, fair enough. How about UTMA or UGMA accounts, uniform transfers to minors account, uniform gifts to minors account? How does the state look at that?
So they're a little different. They still are a resource, but it's an exempt resource. And there's stipulations on that once that individual, the grandchild, turns 21.
Okay, so an UTMA account basically is an account that is set up where the money is kind of held for the minor until they reach the age of 21. And then when they reach the age of 21, of course, the money does get distributed. So at the time that the money would get distributed at 21, the state would look at it and say, okay, well, that distribution was made. It appears in the look-back period. It would be a gift. But prior to 21, it's going to be an exempt resource. Is that a fair statement?
Yes.
Perfect. All right, anything else on UTMA or UGMA accounts?
I don't think so. I think
All
we
right.
covered it.
Well, let's talk about my next favorite topic. Medicaid applications for spouses who are estranged, maybe taking a break from each other. I don't know what kind of term we want to use here. So we have husband going into a long-term care facility, applying for Medicaid. Maybe wife hasn't lived in the house for a couple months, whatever, but they're still technically legally married. How does the state look at an application in that instance?
Well, I think that's a great question because it really depends upon the circumstance. There have been cases where they are truly separated and have been so for 20 plus years, and all of their assets are completely separated. And we have been able to, in those cases, to prove without a doubt that they are, truly living separate lives, and we have not needed to disclose the spouse's assets because we have been able to prove that they are truly separated. However, there are other cases where it may have only been a few months, and they still commingle assets. They may still own the home together, and then those accounts, it would be more difficult to prove that they are separated and not just stating they are separated to potentially protect assets from Medicaid financial eligibility.
And what type of things, just generally speaking, would you be looking to provide to prove it?
So you would definitely have to have statements from different individuals, potentially even a lawyer stating that they have been consulted about a divorce, really showing that the incomes are going into different bank accounts to prove. But it is difficult, when they are commingling funds and paying for bills together, or the one spouse is paying for the other spouse's bills, because in a typical divorce situation, that is not occurring.
Yeah, and one of the things that I always say is anytime we start talking about how to prove something, Sure, it is very possible we could prove it at the caseworker level. There is a chance of it, and it may give them enough information that they feel confident. But generally speaking, when we start talking about proving things and looking at driver's licenses, looking at where bills are going, looking at bank statements, looking at commingling of assets, a lot of times that ends up having to be done at a fair hearing in front of an ALJ, an administrative law judge, simply because a caseworker's job isn't to be the judge. A caseworker's job is basically to look at the facts as they're presented and therefore default to what it is that the state's position is. And of course, in this instance, the state's position would be you're still married. You're especially if you're commingling assets. I think that certainly makes things a little easier. And then from there, I think you have varying degrees of how hard it would be to prove it or how easy it would be to prove it. But generally speaking, if you're married, especially if it's been recent where you've been separated, I think you can definitely count on the fact that it's going to be counted as an asset. So that brings me to the question then, Christine, why can't I just divorce my spouse and give 100% of everything to the spouse who is not in the long-term care facility? Is that a great technique?
No, it's not. One, there has been a case, not that ever came through our office, but from discussing with caseworkers where that was attempted to be done, and just to protect assets. And so in a traditional divorce, you split the assets. So, and now you are a single person, and in a single person's case, we can only protect approximately half of the assets instead of being able to protect everything for the community spouse.
Yeah, and I've always said the state now has an interest in that divorce. So if 100% of the assets went to one person who happens to be the well spouse, if I was the state attorney, I'd be saying, well, now wait a minute, time out here. What would the marital kind of separation rules provide? And if 100-0 is a possibility, all right, then maybe. But I don't know really of a situation where equitable distribution is typically 100-0. So I think in those cases you have to be really careful. I always tell people, go through the divorce, hire attorneys, do it the right way, let the distribution be exactly the way that it should be. And then the state would be okay with it because you followed the proper channels, you went through everything. So maybe it's 60-40, maybe it's 55-45. I mean, I'm making up numbers, but that certainly would be more akin to being realistic than 100-0.
Right, but for the purpose of just trying to protect assets through the way of a divorce, that would not, because whatever the institutionalized spouse did receive, now we can only protect half of it versus being able to protect everything.
Yeah, we've definitely had cases where people come in saying they want divorce because they talked to someone or they read something and then by the time we're done, we learned that it would be better for everybody to stay married, follow the crisis rules, do the community spouse protection allowances, and we can end up protecting a heck of a lot more for the community spouse than what we would have been able to. The only other concept that I want to just mention that we're really not going to talk about in this podcast, but there is something in the federal law that is called spousal refusal. So back in the kind of scenario where we were talking about where somebody's married, maybe they're estranged for a few months, there is the possibility in some states of a spousal refusal, but that is a much more complicated technique. It definitely requires an attorney to understand how that works and the rules with that. And again, I think there's a pretty good chance you're going to have to go to a fair hearing with an ALJ, or at least arguing that one a little further along. But again, every case is based upon the facts. So, we're not even going to delve into that concept here on this podcast, but I just wanted to throw it out there as a lot of states really look at that one as a very viable technique. So it is there, but for our purposes for today, we're going to look at the facts. But generally speaking, if you're married, count on the fact that it's going to count. Which also leads me to a thought that I just had. We get asked a lot, 80, 90-year-olds wanting to get married. So I do just want to throw this out there. If you get married later in life, presumably maybe you have kids, to other relationships, and in some cases, one potential spouse has a lot of assets and maybe the other one doesn't have a ton of assets. So they're quick to do a prenup agreement, a prenuptial agreement saying what's yours is yours, what's mine is mine. And the person with not a lot of money ends up in the long-term care facility. And of course, everybody thinks that the assets are completely protected because there was a prenuptial agreement. I just want to remind you that the state of Pennsylvania was not a party to that prenuptial agreement. And while the state thinks it's great that you agreed that what's yours is yours and what's hers is hers, the state says that's wonderful for your purposes, but you can't now come to us and ask us to provide care or to pay or to assist for the payment of the care when, in fact, the spouse does have assets. So just buyer beware on that one. That's the only phrase I ever learned in law school, by the way, Christina, was caveat emptor. Buyer beware. But anyway, so just I wanted to throw that out there as we were talking. It was triggering for me that I think that's a technique that a lot of people think is an easy solution, and it maybe not as easy.
Yeah, I was actually going to bring that up next, that we should probably touch base on prenuptial, and it would be the same for postnuptials as well.
Oh, yes.
Ask about that also.
Absolutely. Yeah. So, and please don't take this as I'm saying don't get married later in life. That is not what I'm saying. I'm simply saying we need to understand the circumstances, and we need to understand the fact that by doing that, we need to plan or at least know what our options are in regards to how are we going to take care of the long-term care situation. Again, in our pre-planning side of our firm, we can certainly assist with planning for that type of stuff. But in crisis, if a person ends up in a long-term care facility, the general rule is assets of the husband count, assets of the wife count, the spouse's assets count, joint assets count. You can pretty much count on everything counting in that situation. So same rules as the typical Medicaid application and Medicaid qualification.
You know, I've also had the question, because we see more and more blended families.
Yeah.
And so what was spouse A's is supposed to go to spouse A's kid, and what is spouse B's was supposed to go to spouse B's children. And people say, well, that's in their will.
Yeah.
They're leaving everything. And so they think then that means that they are entitled to those assets, and it should not be part of the Medicaid qualification.
Oh, wow.
Because of how the will reads, that it's not going to the spouse, which is the only person that we can protect everything for.
Yeah, and what I would say to those people, if that was a question that I received, is, a will governs what you die with in your name alone at the time of your death. And what we're talking about here is not a scenario that you have passed. You are still alive. You are receiving or needing long-term care. And therefore, that will actually has nothing to do with where we are in life or where we are in this situation. It makes sense. I understand why certainly the families feel that way. But from the state's perspective, look, we're willing to help you. We're willing to provide care for you. But if you're married and the spouse has assets, they are available resources, in which case we as the law firm would be able to potentially help in crisis to protect those assets, but not without doing some planning and without doing some kind of crisis techniques in order to be able to do that. So generally speaking, yeah, I didn't even know that was something that came up actually.
Mm-hmm. Yeah,
wow.
People think because of how the will reads, that governs how the asset should be handled.
Wow. Okay. Fair enough. Do you want anything else on that one, or?
I think we've pretty much covered, because we talked about prenuptial and postnuptials. And
cool. The one thing that I've noticed too that comes up from time to time, and you probably have it come up a lot more just because you're more in the Medicaid meetings than me, is understanding a little bit about a continuing care retirement community and the benevolent care contract that a continuing care retirement community would have, and as well as Medicaid qualification if they are in a nursing facility, even in a continuing care retirement community nursing facility. Could you talk a little bit about benevolent contracts versus qualification for Medicaid?
Right. So the continuing care retirement communities normally have in their admission agreement about a benevolent contract, where when you are out of assets, they will let you basically dip into their benevolent fund to utilize that to pay for your care. If someone is not yet in skilled care, but maybe in a cottage or assisted living, they downsize typically the space that you are living in. And so we have it come up, what happens when I need skilled care or my spouse needs skilled care? Should I just let them utilize the benevolent fund, because that's sometimes what families are informed that that's what it's there for, instead of ever applying for Medicaid? And it kind of depends upon, are both spouses living on that campus of the continuing care retirement community? Is that what you're referring to?
Yeah, we just want to have a conversation. Yeah, we can certainly take it in whatever direction we want.
Yeah. So, I have been informed from people that I meet with that the facility has shared with them that they can utilize the benevolent fund, and they're not sure when they're going to be allowed to use the benevolent fund. And so, how far down of their resources are they going to have to deplete before the benevolent fund kicks in? And should they wait for that time frame to occur, or should they just, go ahead and start the Medicaid process? Because we can still, and have so far been successful in being able to protect the assets in a married case for the spouse, whether they live on the campus or do not, with the understanding, if they're on the campus, that when that spouse needs care, now, all of the assets would be utilized.
Yeah, and I think too, for the listeners, just to kind of take a step back, a lot of times the way that I look at the benevolent fund and where I see it kind of occurring is in the assisted living side. Mm-hmm. So in Pennsylvania currently, we're hoping that changes, but currently Pennsylvania does not pay out Medicaid dollars to assisted living or personal care homes. So you're looking at a situation where somebody's in an assisted living, personal care, maybe memory care unit within the personal care. That's where I'm seeing the benevolent contract really kind of coming in place. Most of the time when a person is placed in a nursing facility, especially as the assets start to come down, the facility itself, the continuing care retirement community, is going to make the family file the Medicaid application. So one of the things I hear all the time is, well, they would never apply for Medicaid because the benevolent contract is going to pay for it. No, if the facility can have the bill paid for, they're going to, because the benevolent contract is basically the charitable arm of the continuing care retirement community, and they're getting people donating money. In a lot of cases, it's a 501c3. They're looking to help the families of the campus. So to the extent that there are funds available through Medicaid or any other source for that matter, of course the facility is going to want that. And in the continuing care retirement community, a contract, they're going to have you sign something saying, look, we're disclosing our assets as of today's date, and we agree from this point forward, we're not going to gift assets, we're not going to give a ton of money away. And so generally speaking, once you commit to that, they're going to spend you down in the nursing facility and then apply for Medicaid once assets are depleted. So you don't, at least I don't typically see the benevolent contract in nursing side, because by that point, typically they're going to qualify for Medicaid.
Right. So sometimes the question comes up when someone's in memory care, which is private pay, and whether or not they should relocate their loved one into the skilled care facility because they are paying out of pocket significant assets privately, and they're in discussion with, using the benevolent fund or relocating a family member to the skilled care side of things.
Yeah, and I think that is a great example of case-by-case sort of discussion about what the contract reads, what the benevolent care contract rules are, what the Medicaid rules are. I mean, that is a phenomenal question, and I think that is where we earn our money, to say the least, as far as, that's definitely a much tougher conversation to give a generic answer to. But you're right, that is a very fine line and a tough discussion. And I do want to say, just for the record, that Christina and I love continuing care retirement communities 100%. This is just simply stating what are some of the things that we're finding as it relates to questions that we're getting.
Yeah,
And so, yeah, absolutely. And all kind of to that vein, one of the things that I have also heard come up a lot is, okay, so if I'm going to a continuing care retirement community, does that therefore mean that I cannot do a trust in any circumstances? No, it doesn't necessarily mean that you can't. It means that when you show up at the continuing care retirement community to disclose your assets to them, you have to have enough money in your name alone to be able to get into that campus, or to be able to get into the CCRC, that you can pay the buy-in amounts, and that the facility feels that you have enough assets that they're willing to give you the benevolent care contract that comes as part of the CCRC. So if you're a family that has just enough to get in, or just enough to get in plus a little, I don't know that asset protection or trust make any sense. If you're a family that has significant wealth, millions of dollars, and you're trying to protect some of those, then you want to get that planning done ahead of time before you go to the continuing care retirement community. And we're still going to want to leave more than enough money in your name alone. We want you to get in where you want to go. We want the facilities to get paid. We want everybody to win. And there is a way under the rules to abide by doing all of that. What I say to clients is, if you do a trust ahead of time, they certainly have the right to say no to you. I mean, they certainly have the right to say. Now, my experience is, if you leave more than enough money in your name alone, well more than what they are typically looking, they're going to take you, because you have more wealth than a lot of people that are coming in the door regardless, and they typically don't have an issue. I imagine that, obviously facilities are going to get more stringent with that, trying to make the number go a little higher. But the truth is, if you have more than enough wealth in your name, of course they're going to take you. They'd be crazy not to. So I don't know if you're seeing anything different in your meetings or...
No, that is, a lot of people are very interested in the benefits of a continuing care retirement community where they know that they are going to be able to reside and that there is this benevolent fund. Mm-hmm. One question that does come up, though, is, well, why can't I do a trust after I've been approved and have moved in? How would anyone know? And they do, they check on the assets periodically.
Yeah, and if you go to apply for the benevolent contract, they absolutely will ask for statements, and it's not a 5-year look back. Remember, the 5-year look back is for Medicaid purposes. It's what's in the box. It's what statements you have to prove. If I'm asking or requesting a facility to pay for my care because I ran out of money, your contract that you sign says that you will not gift assets for any reason to any purpose. And at the sole and absolute discretion of the CCRC, they can determine whether or not they want to honor the benevolent contract. So they can ask you for 20 years of statements back to the day that you filled out the financial information sheet if they wanted to. I'm not suggesting that they do that. Please don't overreact to this. I'm just saying there is not a limit to 5 years. It isn't that. And that also kind of is a great segue into one conversation that I had with a CCRC locally. I mentioned to a client that be very careful gifting. Yes, I understand there's a tax rule that says you can gift, but that contract says that you're not going to. So please forget about the tax rules once you sign a contract. And, this person went to the admissions director and mentioned that I said that they would want to be careful with all of their gifting to the churches. And I said, when the admissions director called me, she's like, that's ridiculous. We would never have an issue with that. And I said, well, that's great then, because, that was really nice of them to give $100,000 to the church. And she goes, well, now, wait a minute. Hold on a second. They gave, I said, no, they didn't. But that's my point, right? There absolutely is a number that you're going to care. And she's like, yeah, you're right. And I'm like, so to tell them that there isn't is not true. And it's not black and white. There is no hard number. They're going to look at the totality of it, and they're going to say, okay, well, since we relied on your financial statement over the last 10 years, you have given away X number of dollars. if they're now being requested to pay for your care, yeah, they have an opportunity to ask why you gave away over the course of 10 years 50 grand or 75 grand. And there is no number that's a magic number that they're not going to cover anymore. That just comes down to facts and circumstances. So you're always better off being careful is all I'm trying to say.
Right. Makes sense.
Awesome. Well, look at that, man. I cannot believe we are out of time. Can't say that I'm surprised. I knew that this would go fast, and I knew that we would certainly spend the entire time talking about wonderful Medicaid tips, tricks, and also some things that maybe aren't so common. So thank you for joining us on the Red Wagon Estate Planning and Elder Law Show. I am Jeff Bellomo, your host. I hope you enjoyed it. Please check us out at www.bellomoassociates.com or give us a call, 717-845-5390. We hope you enjoyed this episode of the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly. Until next time, we'll see you real soon.